Okay, Happy New Year to everybody. Thanks for joining me for the fourth of my 10-part series. And for the feedback that those of you have given me so far, it's very helpful. I do read what you send, and I do incorporate it into my webinars to the extent that I can. If you need to reach me or you have some comments or questions, try to reach me directly. Some of you have been responding to the email invitation. It goes to our marketing group, and it just takes a little longer for the email to reach me. This format is going to be the same as others in the series. I'll talk for about 45 minutes, and then I'll take about 15 minutes for Q&A at the end. But if you have any questions, I've got the Q&A box open, and I will try to answer those questions if I see them. Otherwise, I'll get to them at the end. So just a little bit about me and why I'm doing these sessions. I am a partner and an arbitrator at Lerners and an arbitrator at Arbitration Place. And I conceived of this idea when I saw a bit of a gap between what you see in the case law and the books and how practice actually works. And I'm a huge fan of Brian Casey's book, Arbitration Law in Canada. And I think that's the closest resource that I can find that really gives you a lot of practical advice. And so there are some issues, of course, that he doesn't address or doesn't address in a lot of detail. So that's what this webinar is about and what the series is about. Today's session is going to be on the first procedural meeting and really how to prepare for it and what to expect out of it. For the reasons that I'm going to explain shortly, I actually think it's the most important part of the process. And so the process and the objectives that parties have for cost efficiency and speediness really start at the first procedural meeting. And so really, counsel and the arbitrator have to make the most of it in order to reap those benefits. So I'm going to cover today opportunities for making sure that the process is speedy and cost effective, taking advantage of the case management that the first procedural meeting really presents, and customizing the process to the dispute, which I think is the real benefit of arbitration. And as always, I'm going to suggest some practical resources that you can turn to later in your own practice and make use of them. So what I say today is most relevant to ad hoc arbitration, which is very common in Canada, as probably everyone on this call knows. There may be more structure and less flexibility where the arbitration is international or where it's being administered by an institution like the ICC or the ICDR. But most of the principles apply. It's just there may be, as I say, more restrictions or more structure. So why do I say that the first procedural meeting is so important? The first is that it happens very early. It should happen as soon as possible after the arbitrator has been appointed, for one thing, and that starts the process of dealing with things quickly. It often occurs right after a failed settlement or mediation attempt. So parties have their entrenched substantive positions, but they may not have any discussions or even an idea about what kind of process would work now that they're on to a dispute resolution process. It often happens before pleadings have been exchanged. Pleadings, I'm putting in quotations because that's a litigation term, although we do see that in some of the arbitration rules. And if pleadings have been exchanged, it of course helps identify the legal issues at stake. But sometimes the first procedural meeting happens before that occurs, and all that's happened is a notice to arbitrate has been served. And so the first procedural meeting gets to the heart of what are the substantive issues in the case. And because most parties choose arbitration because it's fast and it's supposed to be more cost effective, everybody in the process needs to keep in mind that those benefits only work if you take advantage of all of the process, I say improvements over litigation in the courts, because each case can be customized. And the courts have rules which are essentially a one size fit all. So the real key, I think, to the first procedural meeting and to the arbitration process itself is flexibility. What will work in this situation, even if it's not the way things are done in courtroom litigation? Of course, people want privacy and confidentiality, and that's something that should be addressed at the first procedural meeting. Some parties have a greater interest in that than others. And this is the first opportunity really to ensure that the case starts off on the right footing to achieve the principles that most people are looking for in arbitration. And after that, it may be too late. As counsel, I think that the important way to look at this meeting is that it's an opportunity to advocate for your client the really important issues. So if you need to have the case resolved in a very short period of time for a business meeting, business reason, that is one of the issues that should come on the table at the first procedural meeting. And there may be issues that parties agree upon and don't agree upon, and then the focus of the first procedural meeting will be on the areas of disagreement. There may be a lot of ground that gets covered, and I think you'll see that in what I discuss about the kinds of topics that are dealt with in a first procedural meeting. So it's really important that counsel come prepared with instructions about how your client wants to deal with these issues. It can be the very first strategic step that you take as counsel, because you're advocating for your client a process that you think is going to achieve the goals that your client has. And particularly if you're primarily commercial litigation counsel and not arbitration counsel, it's important to really keep in mind that the process can be customized, and keep an open mind. If you have an experienced arbitrator, I say that you should trust in the process and keep an open mind about some of the suggestions the arbitrator may make that are not consistent with what you find in the rules of civil procedure. And I've spoken to many counsel who cross that bridge from litigation practice into arbitration, and not a person has said to me that the process that was envisioned, which was different than what is provided for in the rules of civil procedure, wasn't a successful way to deal with it. They may not have liked the outcome, but the actual process and looking at the process from a different perspective was very useful. As a party, what do you get out of the first procedural meeting? Well, first of all, I think parties should attend. It's the first chance they have to see the decision maker, and they can give instructions to their counsel in real time. Sometimes things come up that are not expected. And so one of the reasons why I would even suggest having a first procedural meeting in person is to allow kind of those real-time instructions to deal with things and keep the momentum of the process going. What are the benefits to the first procedural meeting if you're an arbitrator? Well, it's really your first chance to show that you can control the proceedings and make the expectations that you have for how this process is going to run very clear. And while the arbitration really is the party's process, I view the arbitrator's role as having a responsibility to make sure that it stays on track and that there aren't any undue delays. And one of the ways you can do that is make sure that all of the issues that you foresee may arise are dealt with in the first procedural meeting. And I even go so far as to say that a hearing date is set at that first procedural meeting. And I'll talk a little bit more about that. It also shows that you're listening to the party's objectives in the arbitration, the fact that you're setting aside perhaps a couple of hours to talk about what parties want out of the process, and then devising a process that will achieve those goals. And it also encourages, I think, better communication among counsel to the process. And that's something that should be dealt with in the first procedural meeting. I've never really understood why in the court process, counsel don't speak to each other more. And many matters that end up before motions court could be resolved if counsel would simply talk to each other more. And arbitration, for the most part, really helps that, so that the issues that are where they can't reach agreement are really identified clearly and narrowly, and the issues that people can agree with are put on the table as well. And this often means that interlocutory issues can get resolved quite informally and very quickly. And so my view of an arbitrator is that the arbitrator should be somewhat of a case manager, and that the case manager will also hear the merits of the dispute, but also assists the parties in moving forward to achieve their objectives. There are different kinds of arbitrators, and if you go back to your first discussions with co-counsel on appointing an arbitrator, you really need to think about what kind of arbitrator you want. And in Brian Casey's most recent book, his 4th edition just came out, he talks about the referee, the dictator, and the case manager. And I've told you that my real preference is for an arbitrator in the role of case manager, but some parties may want a referee. So somebody who is willing to let the parties control the process and come to them only when there's an issue. And so those kinds of arbitrators will typically have a fairly short first procedural meeting because the process is left in the hands of the parties. And then there's an arbitrator called that Brian Casey calls the dictator, and that's someone who has a very predetermined idea about what the best process is for most arbitrations, and will even come to the meeting, the first procedural meeting, say with a draft procedural order. And it may be that the same arbitrator will have different personalities depending upon the nature of the dispute. But I think it's helpful to look at this process from the perspective of the kind of arbitrator that you may have. I think the most important point to drive home for the first procedural meeting is preparation. And it's very common, and I think good practice, for the arbitrator to signal to the parties what's going to be discussed at the first procedural meeting. And that usually takes the form of some kind of a checklist or an agenda. And parties then have an opportunity to canvass those issues with their client and hopefully with the other side. So how to prepare for the first procedural meeting? Again, set aside sufficient time, because the idea is that the meeting will cover issues from the very beginning, potentially from pleadings through to the hearing. There's a lot of ground to cover. So it may take, say, 2 hours. Set aside the time and make sure that you as counsel have the enough instructions, and you've thought enough ahead about how you think the case is going to go, so that you can address all issues that you think are going to arise at that first meeting. Obviously, that's a very different way of proceeding than under litigation in the courts. Make sure that the arbitrator has all of the necessary documents in order to convene the first procedural meeting. And usually that is just the arbitration agreement, and the arbitrator may have already received that as a result of the appointment process. But also if there are pleadings, the arbitrator will want to see that, and then the business contracts, which are at issue. And that's pretty much all that the arbitrator needs to see at the first procedural meeting in order to understand the issues. Then the arbitrator, as I've said, will set out an agenda, send it to the parties, and the parties and their counsel will come back to the first procedural meeting and have an idea about what the process should look like. And usually this agenda is quite detailed, which means it will have things that many counsel don't think of as issues you deal with at the front end. So what should be on that agenda? It starts with the basics, if this information isn't already available. Who are the players and the participants? The key players and parties, whether there are third-party funders involved, and that's becoming increasingly an issue. Counsel names and contact information, and how communication will be done. Will it be done by email, for example? And invariably, that's the decision that gets made. But for example, for security reasons, the arbitrator will want to be absolutely certain that that's the kind of communication parties want. What's the case about? This is critical. What's the amount at issue? What are the legal and factual issues? And this is not an opportunity for counsel to argue their positions, but to raise the issues. So for example, if this is the kind of case that would benefit from bifurcation, say the liability issues are decided before the damages issues. This would be the time to raise that, because it obviously affects the timetabling and what the hearing is going to look like at the end. Other things like whether costs or interest are on the table. That's not always the case. Sometimes the arbitration agreement deals with those issues. So all of the issues need to be on the table, because that's going to allow the arbitrator to assist the parties in setting a timetable for when each of these stages need to be completed to allow the parties to get to the fixed hearing date. What kind of evidence is going to be heard? Will there be witnesses giving evidence viva voce? Will there be witness statements? And I'll talk a little bit more about that later, because that's a very common way of dealing with evidence in chief. What are the parties doing about documents? Where are they? How long is it going to take to get them? In what form are they going to be received? All that sort of thing. Whether there will be experts. Will there be, each party intends to hire an expert, or do they want to jointly retain somebody, or do they want the tribunal to retain somebody? What kinds of issues do the parties think an expert report will be necessary to address? Are there credibility issues? And I think that's an important question when you think about whether it's necessary to have a hearing at all. And there are many cases that involve a lot of money where hearing evidence is, where an oral hearing may not be necessary, that it can all be decided on written evidence, witness statements, and the documents, and written argument. So after the discussion about what the case is about, the merits, the legal issues, the next step in the first procedural meeting is, well, how do we get there? And what are the steps that are necessary to take from where we are now to the final hearing? And if pleadings haven't been exchanged, then what form will those pleadings take? And pleadings in arbitration look very different than pleadings in civil litigation. They contain facts, they may contain argument, and they usually contain all of the documents that each party intends to rely upon. And so that's a very important distinction, because parties get their case presented quite quickly at the front end. What rules of evidence do the parties want to use? And so the question relating to how do we deal with documentary production, requests for documents, disputes about documents, how do we deal with how witnesses will testify, including experts, what will be the admissibility of the expert report, for example. And a really good reference and a document that the parties may want to adopt is the IBA Rules of Evidence in International Arbitration. And it is about a 20-page document which can be adopted partially or wholly and deals with those kinds of issues. How does the evidence go into the record at the hearing, and what are the steps necessary to get it there? So, for example, it deals with experts. And what an expert report should look like, and how those experts are exchanged, etc. And I'll talk a little bit more about that. And despite the fact that they're called the IBA rules of relating to international arbitration, they're used very often in domestic arbitration. And I think what you see increasingly is a lot of the principles that originated in international arbitration are being adopted into domestic arbitration because of the flexibility that arbitration offers. And so these kinds of resources are extremely helpful, particularly if you're a counsel who doesn't do a lot of arbitrations and you want kind of the structure and the certainty about how issues are going to be dealt with. They can actually provide a lot of comfort so that you understand what the process is going to look like. Documentary disclosure, and this is a huge difference between litigation in the courts and your average arbitration, because there is no obligation generally for parties to simply produce all documents that are potentially relevant. Ordinarily, what parties do is to produce those documents that they intend to rely on. And then there's an opportunity for the opposing party to make additional document requests. And those either result in further production or a dispute about production, which gets resolved by the arbitrator. And the form of those requests is often something called a Redfern schedule, named after a person. And it takes the form of a chart. So a party requesting documents will either ask for specific documents that they believe are in the possession of the opposing party, or a category of documents. And they're required in a chart to identify those documents, indicate why they are relevant and material, explain the fact that the requesting party doesn't have those in his or her possession, and why the opposing party likely does. And the opposing party can either voluntarily produce those documents or object to production on the basis of lack of relevance, doesn't have production, it doesn't have possession of them, or they are privileged. And there may be some other reasons as well. And ordinarily in the process that's envisioned under the IBA rules of evidence and is common in arbitrations, is that where there's a dispute about production, it gets dealt with quite informally by the tribunal. So first of all, you don't have to wait months for a court time. Often you can get the issue resolved on a conference call with the arbitrator, usually without a formal record. There may be some interlocutory type motions that do require formal evidence, but often these kinds of issues can be dealt with on a conference call. The tribunal will issue an order, and all of this can often be done within a couple of days or a couple of weeks. And then that keeps the process moving. So you don't have these long delays while interlocutory disputes get resolved that you see in courtroom litigation. Oral discovery. The fact that it is not something that parties have as of right is often the issue that most counsel doing litigation in the courts normally feel most uncomfortable about. And what I say to you is that you will find that if you follow the kind of process I'm talking about, you won't need oral discovery, or if you do, it will be on very narrow issues and can be limited in time. And so that's another benefit of arbitration with the kind of process that I'm going to talk about, is that you end up saving a lot of the time in oral and documentary discovery and cost that you spend in courtroom litigation, and you keep the case moving more quickly, which is why it's possible in most cases to get a hearing date and a matter resolved within a calendar year. But it also is the explanation for why arbitration can cost less than courtroom litigation. So if a party thinks that oral examination for discovery is necessary, then the process is generally to make that request of the arbitrator and explain why, and the arbitrator will rule. And sometimes, in my experience, there are ways to get the information that the requesting party needs without having discoveries. The next issue to discuss, of course, is experts, and I alluded to that. And there is a very good protocol that the Chartered Institute of Arbitrators has created, which adds some detail to the IBA rules on a great process for dealing with experts in arbitration. And the parties can either agree on this process, and sometimes, because the arbitrator has the ultimate decision-making power over process, the arbitrator may impose this. But it's an extremely helpful way to deal with experts. The expert must certify that he or she is independent, impartial, and not subject to any influence from the parties, which we now see in litigation. That's a fairly new amendment to the rules, and I think it probably originated in the arbitration context. But it also provides for a meet and confer process, which means the experts that have been hired by the parties must meet, and they must together prepare a report in which they identified the areas that they agree about, the areas of disagreement, and if they need further information or they need to do further testing or what have you, they will identify that and ensure that it gets done and meet again in order to generate a further report. And sometimes you'll have a joint report from the experts. Sometimes each of them will generate a report in which they explain why they differ from their colleague. And then the expert report is often used as the expert's examination in chief, assuming there are no issues about the qualifications of the expert and whether that opinion falls within the qualifications. So there may be objections to that. But the expert then prepares, the expert report is often used as examination in chief, and then the expert will come to the oral hearing and testify. And one of the innovations of arbitration has been this concept of hot tubbing, which you sometimes now see in courtroom litigation. And that involves the two experts sitting in the witness box together. And the parties will ask questions of them. Quite often, the tribunal will ask questions. And then after each has asked questions, parties have an opportunity for cross-examination as well. And again, the reason I'm being somewhat general about this is because parties can customize how they want their experts to testify. And it doesn't have to be a hot tubbing arrangement. It can be your typical way of having evidence heard by arbitrators. But I think the most important part of the process that's found in the Chartered Institute protocol is that the parties actually engage with one another, which is extremely helpful, because you probably hear a lot of judges and arbitrators saying, often it's a battle of the experts. I don't have that expertise, and I'm not really sure how to cut through the disagreements that the parties have. So if you're getting the experts to engage with one another, you can cut to the real critical issues. And so that's something that should be discussed at the first procedural meeting as well. What kind of experts will you be having? You may not decide on the process, whether they're going to hot tub or not. That may be for a further procedural meeting. But the more you can get done at the first procedural meeting, the more you keep the arbitration process on track. Another issue to discuss is whether there will be an arbitral secretary. And if so, who? What's that person's role? How much is that going to cost? And critically, whether there are any interlocutory disputes or preliminary disputes that need to be addressed immediately before anything further that can happen. So a very good example of that is if there's a dispute about the jurisdiction of the arbitrator to hear all or a part of the matters in dispute, that will often get dealt with immediately. And the panel then, or the arbitrator, has the discretion to decide whether that can be determined at the outset or whether it is necessary to decide the jurisdiction issue along with the merits issue. And you'll hear where arbitrators decide that they just can't decide this issue as a preliminary one, that they need to hear more of the evidence to understand more about the dispute before they can decide the jurisdiction issue, in which case it will get decided at the very end with the merits issues. The other, another preliminary issue that may come up is the seat of the arbitration if the parties cannot agree on it. So those are the kinds of issues that need to be addressed up front in order for the process not to be derailed. And that's another reason why this agenda really helps, because it gets parties focused on some of these issues when they might not otherwise do that at such an early stage. So then the discussion at the first procedural conference turns to, what will the hearing on the merits look like? Is an oral hearing even necessary? And as I've said, in some contract cases where you've got strictly a contract interpretation issue and there's probably not any credibility issues, you may be able to deal with the dispute determination purely on a written record, as if it were an application, for example. And so that's something that should be addressed early on, because that will obviously affect the timetable. Will the hearing be done virtually? Will it be done in person? Or will there be a hybrid? And it's pretty clear that a hearing under the rules and in the legislation doesn't require in-person attendance. It does allow a virtual hearing. And there are lots of resources that have protocols for how to deal with virtual hearings, which I'll take you to in a moment. Will there be viva voce evidence, or will the evidence in chief go in by way of affidavit? That should be discussed at the first procedural meeting, because again, that affects the scheduling. How will the experts testify? What is the role of the arbitrators? And there's a recent case called Redfern against Morrison Hirschfield, 2022 ONC 3485, which I really think is worthwhile reading, because the case involved a challenge to an arbitrator on the ground that the arbitrator was too interventionist and in fact had entered the fray. That was the allegation made. And the judge hearing the application actually dismissed the application to remove the arbitrator for bias, and in fact said that the arbitrator had done an excellent job in keeping the parties focused and the hearing going forward. And here's why the judge said that. So the arbitrator was very commonly asked questions of the witnesses. And this is more common, again, in arbitration than it is in litigation. And some arbitrations adopt an inquisitorial type process where the arbitrator takes an active role in questioning the witness. And that was the case in this decision. And the arbitrator, in fact, always gave the parties an opportunity to ask follow-up questions after he had asked his questions. And the judge said this was an indication that there was fairness in the process and that parties had an opportunity to respond to issues or address issues that the arbitrator had raised, and that each party had an equal opportunity to deal with this stuff. And so the judge said, rather than entering the fray or being not impartial, the arbitrator was actually signaling to the parties the issues that he was concerned about or thought were important, which in fact gave them an opportunity to make sure that they addressed them. And in fact, he put in his procedural order that that was the process he would likely follow. But it also required that the arbitrator was very, very prepared, because in order to have sufficient information to ask questions of witnesses, including experts, the arbitrator had to be on top of all the issues and the record. And so the application judge said that was a benefit to the parties because they had a very prepared arbitrator. So I think that's a really important case to let you get a sense of how a hearing can go and what kind of arbitrator you want. Another question is whether there will be oral submissions at the end of the day or just written submissions. And that's really a strategic decision, I think, for counsel. Most counsel feel comfortable if they have an opportunity to see the tribunal at the end of the hearing, to have an opportunity to let them ask questions, etc. But it may not be necessary. And logistics. Logistics of the hearing will have to be dealt with at some point. They may not be dealt with at the first procedural meeting, but they should be on the list to be dealt with perhaps in a subsequent procedural meeting. So for example, once the dates are actually fixed, which, as I say, should be done at the first procedural meeting and may be done within a year, there should be a discussion about how long the hearing is going to take, and those dates should go into everybody's calendar. And the first procedural order says generally that there will be no change to the hearing date or to any of the other dates that are in the timetable unless there are unforeseen or unusual circumstances. And so that keeps the momentum of the process going. It means you don't get last minute adjournment requests, for example, very often, and there has to be a good reason. So parties need to buy into a process in which they're moving at a specific pace, and having knowledge about when things are going to happen, I think is very helpful for counsel and parties to prepare. And sometimes what you'll factor into that timetable is the date by which the delivery of the award needs to be made. And sometimes arbitration agreements specifically provide that an arbitrator must deliver the award within, say, 30 days of the end of the hearing. So those things will be discussed at the first procedural meeting. But some of the other issues that will have to be addressed but may not be addressed at the first procedural conference are time limits. So you may agree that this is going to be a 1 week, for example, hearing, but how is the time going to be allocated, and who takes what time? And what I've seen done quite often is that closer to the hearing date, once the witnesses are known and once the issues are clear, counsel will sit down at first instance and set and try to agree upon a timetable. We're going to have 15 minutes for this witness. We're going to have a break at this time. We're going to sit during these hours. You really do have to get down to that granular level if you've agreed you've only got a week, because parties don't want to find out that we're on day 5 and we're not going to get the hearing done, because that may mean a further delay. So that's the kind of detail that you deal with either at the first procedural meeting or later on. Will there be transcripts? Will there be simultaneous transcripts same day transcripts or something else. And it's important. This is a really important strategic issue because there are lots of cases you'll see where the parties have decided to save costs and forego transcripts, and yet they've allowed an appeal right in their arbitration agreement. And so they have not had much success on appeals to the court when they don't have a transcript and there's no real evidence before the court about the complaint that they make about the issue. And this likewise goes to set-asides. So if that's a concern, then you probably need to have a transcript or at least a recording of the process. If the parties want finality and they're prepared, they have trust in the process, they have trust in the arbitrator, and they don't want an opportunity to take whatever decision is made at the arbitration by the arbitrator to another level, then it may make good sense to save the costs of the transcript, because they really can be a significant cost of the hearing. Where will the hearing take place? And this is not only the city, but also what facility, because it may be that will have to be booked fairly quickly. And you want to make sure that you've got the facilities that you need. Are you going to need to have some people participating remotely and some people participating in person? So how are you going to get the technology set up for that? What's the room going to look like? How's it going to be configured? Who's going to sit where? I mean, all of those details we often don't think about until the last minute, but it may be necessary to deal with them early on if you've got to get a third-party vendor to provide you with that. The other issue that sometimes comes up at the first procedural meeting is whether the arbitrator should be leaving time for the parties to have settlement discussions. And there's really no consensus about whether the arbitrator should raise that at all. I've heard the argument that because the process goes so quickly as compared with courtroom litigation, that parties sometimes don't feel that there's a sufficient gap to kind of catch their breath and evaluate the evidence. And I personally think that's rarely an issue. Usually parties have had early settlement negotiations before they go to arbitration, and they don't think they can settle, but as the case unfolds, they may be rethinking their case because they may not have had all of the evidence, for example, at the time of the early negotiations. So the question really is whether the arbitrator suggesting mediation or some kind of settlement discussions would be helpful. And again, I don't think there's a consensus on that, but if the parties would like that, it can be built into the schedule. So generally, where there are issues that arise along the way, the arbitrator will decide them if the parties can't agree. So this is another reason why you want to have as much discussion beforehand, so the parties have the greatest control over the process, because at the end of the day, the arbitrator has the jurisdiction to make rulings. And if you would like to have if parties would like to have more of a say in the outcome, we tell our clients it's best to try to negotiate a resolution. There are obviously some issues that the arbitrator will have to address, and those are the big picture issues, like somebody thinks that a case should be dismissed at an early stage, or there's a jurisdiction issue, and those sorts of things are likely not going to be resolved, and the arbitrator will have to make those decisions. So let me tell you a little bit about what the typical process looks like, so you can understand, if you haven't already experienced this, how a front-end loading of the evidence can work to reduce the cost and the time of the arbitration. And this is typically called evidence-first arbitration, and it's a term I heard for the first time from Bill Horton, who's a very a well-known arbitrator. And he's written a paper about this, which I will circulate at the end of this session, or after this session. And it describes a process that is very much similar to the application process in a court proceeding. And what that means is the evidence all comes up front, and then there's legal argument, and sometimes there may be a requirement that some issues are heard through viva voce evidence. So if you look at it in that context and you consider how much more efficient, both in time and costs, a court application is, I think you'll understand what this process is designed to achieve. And it can work in large matters worth billions, millions of dollars, where the issues are fairly complex, and it can of course work for small matters where the damages are not great and the legal issues are not all that complex. And the objective is to obviate the need for oral and documentary discovery, and that's possible because parties' evidence comes in the form of affidavits or witness statements at the very beginning of the process. And usually once that happens, a party on the other side will understand the case that it has to meet and what witnesses will be testifying about those issues and the documents that will be relied upon. And that's generally what the purpose of discovery is, including admissions, which sometimes will be found in those witness statements as well. So the whole purpose is to get on the table at an early stage what the evidence is and what the issues are, so that parties understand them and can narrow the focus immediately. Litigation starts broadly and gets narrowed through the discovery process, while as arbitration under this model starts narrowing the issues immediately. And so there is no need for fulsome production of every single document that may possibly be relevant, because relevance is determined not only by the pleadings, but also what's in the actual affidavits or evidence. So if you look at, apart from the fact that the evidence in chief goes in by way of affidavit, how does the whole process work if you're doing an evidence first arbitration? So the pleadings will often attach, as I said, the documents that the party intends to rely on. So the opposing party who's then responding to the pleading knows immediately what's important. And as I said, there's often legal argument. So you start even at the pleading stage, winnowing down the issues and the evidence so that everybody's on board and they know what's important. Usually the process provides that at any point in time, a party may request additional documents or information. And I've said to you how that gets done, generally in a Redfern schedule. But what this means is that a party that is concerned that it doesn't have the documents that it needs to prove its case, and all of those documents are in the possession of the other side, and that happens in some cases where all of the evidence is in the possession of the other side, that the party can have the comfort of knowing that they are entitled to ask for that information or that evidence. And if there's a disagreement, again, it gets determined by the tribunal. And early requests are best, because if you wait too long, your request may be denied. If you've already sent out your witness statements and you later ask for further information or documents, the arbitrator will want to know why you didn't address it in your earlier witness statements or make an earlier request. So again, that kind of idea forces parties to decide on the evidence that they're going to use very, very early. Interlocutory disputes often are decided on short notice. And part of that is because scheduling is very easy in an arbitrator. You've got the arbitrator and counsel. And so you can often get things heard very quickly, often without the formality of a motion record. I've said that sometimes things get dealt with in a conference call, and that is very common when you're dealing with discovery type disputes. And then once you get the evidence in, so there may be exchanges, there may be a simultaneous exchange of witness statements. That may not work. It may be the claimant goes first and the respondent responds, and then there's a reply. It may depend upon the case. And it may be that the issues are being dealt with, as I say, they may be bifurcation, or there may be issues that are dealt with separately, in which case the process may vary. But this is just kind of the general type process. Each party will have a chance to respond to the opposing parties, these evidence. And cross-examinations on those witness statements then takes place during the hearing. And that is really helpful again in reducing cost and time, because parties have an opportunity, counsel have an opportunity to prepare for the cross-examinations. It's not like you're listening to the evidence for the first time on the witness stand, and then you've got to take a break for a half day and prepare for the cross-examination the next day, or equally time consuming, you've prepared in advance a cross-examination and you're going to go ahead with it, even though some of it may no longer be relevant because you didn't know what exact issues were going to be relevant until you heard the evidence, and now it's too late to kind of modify your cross-examination. So those are some of the ways that you can save time and costs in arbitration. It shortens both the time from pleadings through to the date of the hearing, but it also shortens the time of the hearing. It eliminates, for example, the need for a summary judgment motion if that's contemplated by the parties, because you can get your hearing heard usually earlier than some summary judgment motions, but the process itself is in some ways like a summary judgment motion, or can be if that's the way you structure it. So these kinds of things, again, those strategic decisions get made at the first procedural meeting, which means counsel need to come prepared, understanding their case and understanding the best way to have it put forward, including the evidence that they intend to rely upon. So that's really what I wanted to say about the importance of the process. Something very quickly to say about virtual hearings. There have been some detailed protocols that have been developed over the course of the pandemic, and many of you have seen them, and they involve things like making sure that there's a technical test before the actual proceeding, but they're really important to review in detail, and you may want to have them included in a procedural order by the arbitrator, because another way to ensure that you're not going to have delays in the hearing is to ensure that you've agreed upon the platform. You may want to hire somebody to host the arbitration, like Arbitration Place, so that if there are technical issues that arise, somebody's there to troubleshoot, and you're not going to lose half a day or a day trying to figure them out. You've got, requirements like everybody should be connected to a VPN and not through Wi-Fi, because that can have an unstable connection. Those sorts of things are really important to address. Whether you're disabling a chat function for example in whatever platform you're using, because sometimes that can result in privileged communications mistakenly being sent to other people. I mean, all of those things are important. So if you want some ideas on the kind of terms you should be wanting in your first procedural order, or some things you should be thinking about to make sure that you don't have any technical glitches in your virtual hearing, take a look at the AAA ICDR Model Order and Procedures for Virtual Hearing document. And again, I'll send this to you. It gives you both terms that you might want in your procedural order and also procedures for making sure that you don't have any technical glitches. And then there's an ICC checklist for a protocol on virtual hearings and suggested clauses for cyber protocols. It's also great. Other time-saving costs and devices that you can build into your first procedural meeting if that's what the parties want. MedArb. That may be a way that you can resolve the issue early with the assistance of the arbitrator, and if it doesn't work, you turn to arbitration. Think about that before your first procedural meeting. Is that something you want to do? Final offer selection or baseball arbitration, in which each of the hearing proceeds, each of the parties makes an order, a draft proposed outcome order, and the arbitrator simply chooses. So what you eliminate is the costs of the arbitrator rendering reasons. And what you do is you just get a result. Of course, if you want to keep open the opportunity to challenge the award, that doesn't work. But if you want certainty, that would work. Hearing and writing alone, that obviously cuts down on time and costs. You can ask the arbitrator not to prepare detailed reasons, and the arbitration legislation requires written reasons unless the parties decide otherwise. But if you decide you don't want detailed written reasons, you can stipulate that, and the arbitrator will give you whatever short reasons mean in the context of that arbitration. Again, a warning: if you want to leave open the opportunity of a court of an appeal or a set aside, then you'll want more than that. Virtual versus in-person hearing, it can save you costs if you have people who don't live in the jurisdiction testifying remotely, and agreed statement of facts. So those are some issues, some ideas that I had about other ways that you can reduce costs and things that you could raise at the first procedural meeting. I think the first procedural meeting is really all about case management as I've said. So if parties simply adopt the rules of civil procedure, that tends to result in higher costs because you've got all of the issues that come up generally in litigation, but you then got the cost of paying for the arbitrator. So that's why I'm really very much encouraging a different approach. And I think most arbitrators believe that as well, but sometimes counsel and parties don't yet have the faith. If you are not, or your client is not ready to forego having a judge decide the merits of the dispute, you can actually refer only the interlocutory parts of your dispute to arbitration. And so you can get the discovery motions and the undertakings and refusals motions dealt with by an arbitrator. And what that does is it gets you ready for trial earlier. You get all those things out of the way for less cost than would probably be required in court, and you get to set the action down for trial earlier. So another cost saving measure. Another issue, which I don't have time to deal with in detail, but it's becoming more and more important, is confidentiality and cybersecurity issues. Some rules and some arbitration agreements deal with confidentiality, some don't. Some define what is confidential in the context of an arbitration, some don't. So if confidentiality or sensitive information is important to your client, you really do need to explore this. And there are a whole bunch of measures that you can take in order to increase the likelihood that you're going to have a secure environment for the arbitration. Things like strong passwords, multi-factor authentication, encryption of data, et cetera, et cetera, et cetera. And there are lots of documents out there right now that talk about how to do that and the practical ways to ensure this kind of privacy and sensitivity of confidential information. And one of the best documents is the ICA New York City Bar CPR protocol on cybersecurity and international arbitration. And if you just Google ICA protocol on cybersecurity, you'll find it. But again, I will send you on that. And just before I conclude, the Chartered Institute is actually going to be putting on a 3-session conference about these very issues, how to address these issues in the first procedural meeting, how to ensure the security of your environment. And one of the most important things is how to make sure that each member of the arbitration process, the arbitrator, the parties, their counsel, the witnesses, are not the weak link that results in some kind of a data breach. And there may be some kinds of disputes in particular where states are parties, or where there's it's high profile and lots of press, where people really do need to turn their minds to these things, because there are an increasing number of hackers out there looking to hack not only the hospitals. We've heard about sick kids and Toronto General recently, but also arbitrations. So this is going to be, I think, very soon part of the duty of arbitrators to be familiar with this. So at the end of the day, all of what has been discussed goes into procedural order number 1, it's called. And some of those issues, as I've said, may go into subsequent procedural orders, but that forms the foundation for what the process is going to be like, and that the parties cannot deviate from it except in exceptional circumstances. So I hope you can see how important it is to do preparation up front and to really think about a lot of these issues in order to take real advantage of a lot of the benefits that can be achieved by having a flexible process. So I will get to, there's a few questions in the chat box. I will get to that in a moment, but I just want to let you know about my next webinar will be on February the 9th, and I'm going to talk about evidence in arbitration. And it's really, to skip to the end, it's really all about fairness and equality. So that's a preview of what's coming next. So right now I've got a few minutes and I'll address the 2 questions that are in the chat box. I'll read. The first one says, while dealing with many issues, topics up front may help to mitigate pitfalls later, it also advances legal expenses for the parties, given the work needed to prepare to deal with all of this early in the process. We see the same phenomenon in modern rules governing court litigation. A balance needs to be struck between addressing too much too early, especially when we consider that many disputes settle before hearing. A pre-hearing conference can also address some matters later on, just before the hearing. Thoughts? I agree. There may be cases where all of the issues that I've addressed simply cannot be decided in the first procedural conference. There are too many uncertainties. Some of those may not be within the control of the parties themselves or counsel. So what I've outlined is kind of a best practices if this is what you're trying to achieve model, which may not work in all cases. But so long as counsel are aware of the opportunities to shortcut some of the processes that we think are sacrosanct under the rules of civil procedure, it still advances the objective of saving costs and shortening the process. And if the hearing cannot be done within a year, but it gets done within even a year and a half, you're still beating the 5 years or so time it takes to get civil litigation done before through to trial, and that doesn't even count appeals. So there are still merits to this process if the either parties or the counsel aren't prepared to adopt it entirely. The second question is, can you provide the site of the decision on the challenge to an arbitrator claiming that they were too interventionist? Yes, it was Dufresne against Morrison, Hirschfield, HERSHFIELD, 2022, ONSC 3485. We've got 3 minutes left if there's another question. Otherwise, I will remind you that I would love to hear from you about comments on this webinar or others you've attended, or issues or topics you'd like me to address in another future webinar. Okay, I don't see any further questions, and I promise to get you out by 1, and it's 12:57. Have a great day.